This episode of Simple Civics Greenville County is brought to you by Dolly Parton's Imagination Library, providing free books to children 0 to 5 throughout Greenville County. To sign up, visit greenvillefirststeps.org/freebooks. That's greenvillefirststeps.org/freebooks.
You've heard it said that where there's a will, there's a way. Today, we want you to understand that when there's not a will, as in a last will and testament, there is a lot of headache, heartache, and cost for those folks you leave behind after you die. I'm Katie Smith with Greater Good Greenville, and on this episode of Simple Civics Greenville County, we will talk all about wills and advance directives, how important they are no matter if you have multiple homes and investments or just a few belongings, and how to go about putting a will and advance directive in place. We have two experts covering this topic for us. Former Greenville County Probate Judge Diane Smock, who serves in many community roles, including as a member of our Board of Directors for Greater Good Greenville, talks with Jessica Ferguson, an attorney with Turner Padget. They refer to many helpful resources. We are reposting this episode in August 2025 in honor of Make a Will Month, and a few things have changed since they first recorded their conversation. Up until May 8, 2025, South Carolina allowed simple probate for small estates under $25,000. But now, under a new law, that has increased to $45,000, offering broader access to streamlined administration. Also, while wills don't legally need to be notarized in South Carolina, doing so, especially by adding a self-proving affidavit, can simplify probate by removing the need for witness testimony. All of these links are in the episode page. Please share this information with the people you love and make getting a will and advance directives a priority on your to-do list.
So, Jessica, let's just start with the basics. So, what is a will?
Sure. So a will is a piece of your estate plan, and it's a document that should be in writing. It needs to have two witnesses. It needs to be signed by the testator. That's the name of the person who's actually having the will drawn up for them. And it should be notarized. And a will is really important because it gives your family direction regarding what you would like done with your assets after you've passed away.
And do you have to be rich to have a will or have a lot of money, a lot of property?
So no, I actually advise that everyone over 18 years old should have a will. A will is a way to honor the estate that you've built during your lifetime, no matter the size. And it also acts as a way to give your family direction regarding whatever assets you may own. It could be anything from a huge estate to a single vehicle. It's a way to give your family that gift of direction after you're no longer there.
And do you have to have a lawyer to do a will?
You don't have to have a lawyer to have a will, but as a lawyer, I would advise you to at least have an attorney look at a will that you have drafted up yourself. Although there are very few statutory requirements to have a valid will, having a good will is a different question.
And I'll just jump in and say I've seen cases where people got, for example, forms off of the internet that purported to be valid. And sadly, when they had to file them, they learned that they were not. So
Right. As a litigation attorney, sometimes I help on the probate administrative side of this area of law where I'm actually having to clean up a will that wasn't done properly, wasn't maybe completely flushed out. For example, one case, just speaking generally, this gentleman had a will that was drafted online. And in one area of the will, he had given his house in totality to one child. And then a few pages further down, he had given the same house in totality to a second child. And unfortunately, neither of these children get along, and two people cannot own 100% of one house. So although he might have saved a little money up front, drafting this will himself, drafting it online, it actually ended up being a messier litigation case on the back end. So that's just kind of a testament to do it right up front, take care of yourself and your estate while you're living. And then again, it would act as a gift later on to your family.
Another topic I've heard that a lot of people talk about is that they don't make a will because they think it's going to be expensive. They hear that probate is expensive. It takes a lot of time. And why should I give the probate system the money when I want my loved ones to inherit it? What has been your experience in that?
Yeah. So having a will drafted generally, I will say, is always cheaper than having an attorney clean up your estate on the back end. But typically, having a basic estate plan drawn up is very reasonably affordable if you are an indigent client. So if you are under 200% of the federal poverty level, you can apply to South Carolina Legal Services. I served there for about 2 years, drafting estate plans for those who couldn't otherwise afford them. And I just can't speak well enough about this organization and its ability to provide estate documents for those who wouldn't otherwise be able to purchase them. But otherwise, I do recommend just maybe meeting with a couple of estate planning attorneys, asking them their fee schedules to be pretty straightforward with you. But it's always better to have an estate plan than to risk potential litigation after you've passed away.
And I would also say on the probate side of things, at least in Greenville County, which is the largest and busiest probate court in the state, but most of them that I'm familiar with, and you've worked in Richland as well, also a great court. The staff is very professional, very helpful. But while they can't render legal advice, they can help if you need to do an inventory and appraisement, don't know how to do it, they'll help you fill out all the forms. All the forms are online, and it's easily accessed, and people are always available to answer your questions. So I would say even if you have a small estate, let's say you own a house and a truck, which is not unusual that's the total estate, you still go through probate, but it's very simple. There's a very minimal cost. In fact, there's such a thing as a small estate proceeding, which if it's a certain amount, if it's under a certain amount, it's just basically 1 or 2 pieces of paper.
Right. So for the small estate, it's if the total value of your estate is less than $25,000, and if you do not own real property, then the entire probate process is just one form, the small estate affidavit, and it's very straightforward. It's very pro se friendly, meaning you shouldn't need an attorney to help you through that. But of course, there are attorneys out there who can. On the flip side, to probate a full estate, which means the person who's passed away owns over $25,000 in assets and or real property, the probate administration process is going to take a little bit longer. So it's going to be anywhere from 8 months to 1 year after this person's passed away, from the day their estate is filed until the day it closes. Whenever there is a large estate, there is a creditor claim period. So anyone that the person who passed away might own money to can file claims against their estate, and the personal representative will deal with them that way. But again, the way South Carolina has designed the probate process, it's supposed to be pro se friendly. It is very form-based. And as you mentioned previously, the probate staff, although they can't give you legal advice, are incredibly helpful, incredibly friendly, very supportive, and they all very much are here for our community.
Correct. So let's talk about a little bit about what happens without a will. And I'll just jump in, and I know you have a lot to add as well. So if someone, for whatever reason, dies without a will, the South Carolina law dictates how the estate will be divided. And let me just mention that all probate law is state law dependent. So each state does have different rules. Let me just throw that in quickly on the, for example, if you've moved here from North Carolina or Georgia, a neighboring state, for example, and you think, well, I've already got a will, I don't need to do a new one. You really do need to at least let an attorney look at it, because every state has different rules about who can do a will, how the will is witnessed, how it's attested, all the technicalities
right.
we lawyers love.
Yes.
But it's worth, again, just an appointment with the lawyer to at least make sure that the will you did in another state is valid in South Carolina. But let's say you don't have a will, either a valid will or you don't have any will, and you die in South Carolina or in Greenville County particularly. What will happen? Well, essentially, you're letting the state legislature decide what happens to your property and who will administer it. And that can lead to all kinds of complications, even if you believe at this moment in time, as you're thinking about this, because you're listening to us discuss it, well, everyone in my family gets along. The kids are fine. I don't own that much property. I don't need a will. I don't care what happens. But unfortunately, many, many times, unexpected things can happen later in your life. Hopefully now you're healthy and well, but you could have health problems later and have to deplete some of your estate to pay for health care, for example. and your children are depending on an inheritance to pay for their education, and there may not be money there. There are so many things to think about. If there's a situation where there's a prior marriage and the children from the prior marriage don't get along with the spouse who's married to you at the time of your death, a lot of lawsuits have come out of that situation when there's no will that makes it clear what your intentions are. If you have a special needs child, you need to provide for them, set up a trust for them, for example, is just one example. Because if you don't, then the court will have to appoint someone to manage the inheritance for that child. So again, you're allowing the state not to just to divide your assets upon your death, but also perhaps manage those assets for those who inherit, depending on the circumstance. So there's just example after example of things that can go wrong, unintended consequences, unexpected circumstances that can have a huge impact on what you thought was going to happen. Jessica, I'm sure you have a lot to add to that.
Yeah, sure. So I just wanted to kind of define testacy and intestacy. So testacy means you have died with a will. So that means someone has died testate. Intestacy are the South Carolina Code of Laws that dictate what happens to your assets after you've passed away if you don't have a will. So that would mean someone who passed away without a will would mean that their estate is being probated intestate. The way this works in South Carolina is if you are married and you have no children and you die without a will, everything goes to your spouse. Pretty straightforward, right? However, when you start having children and you don't have a will, if you pass away, half of whatever you own goes to your spouse, and half of whatever you own is then divided between however many children you might have. So this is where some difficulties might begin to come up, right? Because if a child inherits a piece of real property, say their name is now on a house, that house is essentially legally frozen. That cannot be refinanced, it cannot be mortgaged, it cannot be leased, unless that minor has a conservator appointed for them through the probate court, as you had just mentioned. As you can see, and probably imagine, this can also create issues over generations, right? So in South Carolina, we have an issue with what's called heirs property. And heirs property is any piece of real property that's commonly referred to as family land that's owned by usually more than two family members. So especially in the low country and the mid country, we'll see large pieces of family land that maybe was first purchased by someone's great-great-grandparents. And unfortunately, they didn't have wills. They passed away with multiple children. Maybe their multiple children didn't have wills. And you actually end up in a situation where there could be 20 plus people who own one portion of land. And that can be difficult because each person as an owner has full legal rights to the land. They have the right to be there, to occupy. They also have the duty to pay their percentage of the taxes, insurance, and maintenance on the property. But does that always happen? Unfortunately, no. And then especially thinking about my time at Legal Aid, these heirs property issues, because there's not clear title, which means you either can't tell who all owns a portion of the property. Maybe the property is still titled in the great-great-grandparent's name. And then the person who's living there now actually cannot qualify for home repair services. So, for example, Habitat for Humanity and Rebuild Upstate, both fantastic, wonderful organizations, they have to have clear title to be able to legally work on a piece of property. And unfortunately, when the person living on these properties may need some financial assistance, repair assistance, they're not able to qualify because of the way the title is for this property. So all that to say, this is another reason to get a will, is because it not only protects your assets after you've passed, but it could protect your assets for generations.
And I'll add another complication that I've seen quite often. Again, you may not think listening to this, this will never happen to me, but these things do happen quite frequently, which is there are missing heirs, particularly in this situation you described, when there hasn't been a paper trail through generations, one or two or more generations. So if heirs are missing, whether in that situation or any other reason, then you are required by state law to file an advertisement looking for the whereabouts of the person. And the law says in a newspaper of general circulation, which I'm not sure what newspaper that is in 2022 or 2023. But not only delays things, it requires more court hearings, more paperwork, just more complications. And I think it's really important, too, to step back and remember when you're going through probate, regardless of who's handling things, it's not just a legal process. It's a very emotional time. In most cases, the person handling these papers and forms and processes has lost someone very dear to them, maybe the person they love most in their life. So they're dealing with a lot of emotional trauma, a lot of stress, a lot of worry for a variety of reasons. And so the simpler the probate process can be, or the process after death in terms of the legal issues, the better. So you can avoid so many of these stresses by doing a will, even a simple will, if you feel like you don't have a large estate or a taxable estate to worry about those complications. Having a will can eliminate so many problems for the people you love.
Judge, I have a question for you now. So during your time when you served as Greenville County probate judge, you saw hundreds of families dealing with death of a loved one, right? Or maybe even a not-so-loved one, if there was strife in the family, of course. What would you say to family members who may be uncomfortable talking about a will because they're uncomfortable thinking about death?
The thing, it is hard for a lot of people to face up to, and it's, I think it's human nature. We want to avoid thinking of that's a very difficult topic. So I always encourage people to talk to those, first of all, to talk to people they trust, advisors they would trust. It might be a clergy member, it might be another family member, whoever they trust to give, solid advice about, planning ahead for the future when they may not be there and becoming comfortable with talking about it. But even in absence of that, if I had an opportunity to speak with them, I would remind them of some of the problems we've talked about today that can come up on a regular basis for a lot of people. And just say, if you truly care about what happens to your loved ones after you go, this is the most loving thing you can do, is to plan ahead. With your will and also other advance directives, which I think we'll get to in just a moment. And I having gone through this myself with my parents and then with my husband for our children and now our grandchildren, it can be awkward at first for some folks, but I think having a family meeting when everyone discusses this, it means that everyone knows what the expectations are. They know the realistic hopes and dreams of the person who may predecease them. And it gives everyone a chance to be on one page and know they're doing what their loved one wanted to happen.
Thank you for that.
Mm-hmm.
So thinking about estate planning on a broader scale, so we've already covered the will, but whenever I am meeting with a client, I typically always advise that they also have a healthcare power of attorney. So that's a form here in South Carolina where they can appoint an agent, usually a close family member or a friend, to make healthcare decisions for them when they're unable to do so themselves. So if you think about it in context, maybe someone is on a ventilator from COVID, right? That would mean their agent would then be able to make healthcare decisions for them while they're unable to. I also always recommend a durable power of attorney. So that functions similarly to the healthcare power of attorney, but in the financial side of your life, right? So this appoints an agent, again, should be a trusted friend or family member to manage your finances for you, typically in times when you're unable to do so yourself. So if you're unable to make your mortgage payments, maybe you need someone to talk to an insurance company on your behalf, that will allow your agent to do that for you. So putting those two documents in place in addition to your will ensures your well-being medically and financially during your lifetime, even at situations where you're leaning towards end of life, right? And then also takes care of your assets and your family members after you've passed away. Now, there are more complex estate planning documents. For example, there are trusts. There's many different types of them, and they are commonly used as a vehicle to actually avoid the probate process. You don't have to file a trust with probate court, unlike a will, and the administration takes place outside of the probate court, so there's less court oversight. But typically, trusts are more so used for more complex estate planning needs. And if you have any questions, feel free to reach out to me about that afterwards. But really what we want to impose the importance of today is that last will and testament, and then that healthcare power of attorney and that durable power of attorney.
And thank you. And I would say, Jessica, those two documents in particular, and by the way, we refer to that whole category of documents as advance directives, as opposed to the will, which deals with your estate. The advance directives deal with your property and your health care while you're still alive. And similarly to what we described with the estate and probate situations, I've seen some really heartbreaking situations with people in situations where they did not have an advance directive. And I remember one in particular, it was just heartbreaking to me. It was involved, I want to be careful not to give away facts that might reveal who I'm talking about, but it was an individual who in the line of his service, public service, I'll leave it at that, was wounded quite severely. And for about 10 years, he was in a medically induced coma and was not doing well. And he had two very loving daughters. This was not a situation where the family was in disagreement in terms of not getting along. This was a very close-knit family. These two daughters, these sisters, loved each other and they loved their dad. Unfortunately, they could not agree on what they thought their dad would want. One of them thought that he would want the life support system, quote, unplugged, removed. The other thought that he should be kept alive at all costs. So they ended up in court, and we had a 3-day trial. Again, it was just heartbreaking to everyone involved. So on Friday afternoon, we recessed for the weekend. I said we were done, and I said, I'll have to take it under advisement. I'd like to rule from the bench. I'd love to give family certainty so they could move on. But in this case, I said, I'll take it under advisement, and I'll have a ruling for you next week. And essentially, that put me in the role of playing God. There's no simpler way to put it, because this man's life literally was in my hands. There was no medical reason to do either. What was in his best interest? I didn't know. There was no scientific or legal guidance for me. The people who loved him the most couldn't agree. There was no guideline. Providentially, the man died over the weekend. So I didn't have to make that decision. But I think about that. I still, all these years later, I think about that case so often and just think if only he'd had a healthcare power of attorney and had discussed it with his children, they would have avoided the emotional pain of what they went through that period of their lives. So it's really important. And again, you may be in the best of health, but something can happen today. A truck can hit your car, or there are a lot of things that can happen. The more you prepare, the more you're protecting those you love from more pain than they will already be suffering.
Yes. And not only that emotional pain, but it also could save them financially from having to hire their own attorneys to go through probate court litigation.
Exactly. So Jessica, here's a question that used to get asked a lot, and I'd never really thought about this until people started asking me this about when you have your will done. Let's say you've done all the things that we've advised you to do.
Yes.
Now what happens? You've got your will. What do you do with it?
It should absolutely be kept in a safe place, either a safe deposit box, a fireproof box. But please tell your personal representative, the person you've appointed as your personal representative in your will, where the original is. In South Carolina, only the original will can be filed with the probate court. If someone passes away and you can only find a copy, you're either going to have the consent of everyone mentioned in the will, or again, you're going to have to hire a probate attorney and actually litigate regarding that copy of the will. So please, please, please keep your documents somewhere safe. Let somebody know where they are. And that should also be where you keep your advance directives as well.
And I would suggest, just excellent advice, I'd add to that, keep a copy if you have, in fact, I would make copies for everyone mentioned in the will. Again, promoting that communication, just put everything on the table. And then here's a little pro tip, I guess you call it a life hack these days. I used to tell people who said, well, I don't have a safety deposit box. I have nowhere to keep it. Wrap it up carefully in plastic wrap and aluminum foil and put it in your freezer. Freezers do not burn. And if you're unlucky enough to be robbed, most burglars don't check the freezer. So There's a little cheap, easy place to keep your will and other important documents.
Ah, fantastic. I will start telling my clients that. So we've talked about the importance of having a will and a few other advance directives. We've talked about reasons to have a will, reasons why they're important, but where can you actually get a will done around here?
Well, that's a great question, too. There are a lot of attorneys in town that not only specialize in it, but also have general practice and can, if you have a relationship with an attorney, even if they don't do wills as part of their practice, would be happy to refer you to someone. If you don't know an attorney or don't regularly use an attorney, the South Carolina Bar is a wonderful resource and can not only refer you to attorneys, but can answer a lot of questions for you on the basics. They have a great website, scbar.org, and you can go on there and see a lot of information. In addition, the local Greenville County Probate Court has a lot of their forms and other documents online, and they offer I believe it's a monthly class for those involved in probate. And even if you don't have an ongoing estate, if there's room in the class, you can sign up. And if there's room, they will be happy to have you. And they just explain the basics, show you the forms, and it gives you a chance to get comfortable with what the process is all about.
In addition to that, the South Carolina Bar also has a committee called the Young Lawyers Division Wills Committee. And the purpose of this committee is to host wills clinics all over the state of South Carolina, where you would be able to go in as a participant. You would do a quick questionnaire. You'd be paired with an attorney, and they would draft your will right then and there, and you'd leave with it. So we try to do those at least quarterly. So I would recommend maybe keeping a lookout for that. We do try to advertise in our local communities, but that's a fantastic opportunity to obtain a will. There are also veterans clinics, wills clinics that are held around the state. I believe there are first responders clinics as well. So there are opportunities out there.
And finally, I guess another topic we can talk about briefly is updating wills.
Yes.
And although people, they say, gosh, it's hard enough to go do it the first time. You want me to do it again? But of course, it's important if you ever have a significant life change. I mentioned earlier, if you move across into a different state, it's very important to make sure that whatever state you're living in, your will complies with its laws. If you have a significant personal family event, if you have a marriage, a child is born, a grandchild, a divorce, any significant event, or someone in the family has a life-changing health situation, it's always good to, at very least, get the will out and review it, and perhaps have your lawyer review it and make sure it still addresses your needs. But again, a lot can happen in 10 years. That's why you just use that as a rule of thumb. 10 years can make a lot of changes in your life. So it's always good just to check it, make sure it still says what you want it to say. So, Jessica, when a loved one or a friend of mine dies, and I know that I'm responsible for the estate, what's the first step to take to get the process started for administering the estate?
Yeah, so the first step will be to receive the death certificate. You can usually receive that from the funeral home, or you can request it from DHEC. And then you will take that death certificate along with the original will of your loved one to the probate court in the county where they lived in. So wherever they resided, that's the probate court within the county you would file the will and the death certificate in. Depending on the size of the estate, that's when you would either file for a small estate or you would file for a full estate administration. There are 2 separate forms for each estate. If you're not quite sure which one to use, the staff at the probate court could probably point you in the right direction. Once you complete that and you file it, then the probate court will review your filings. And if everything looks good, the will was executed properly, you are appointed personal representative within the will, and it's the right county, the probate court judge will issue an order naming you as personal representative. You'll then receive a certificate. It's a 1-page form with the judge's signature on it, the judge's seal that says you've been appointed. And that's the document you can use to then access the decedent's bank accounts. For example, if you need to find out the balance in those accounts, if you need to transfer property, you can use that certificate to do so. But again, the whole estate administration process takes anywhere from 8 months to 1 year after it's been opened, just because you do have to be aware of the creditor claim period. because unfortunately, anyone that this person may have owed money to at the time of their death, they get the first bite of the apple, right? So they're going to have priority to file claims against the estate, which the personal representative would then review and respond to appropriately. Once creditors have been dealt with, that's when you as personal representative follows the will and makes sure everything that the person owned is transferred appropriately. So you would do a deed of distribution if you're moving a piece of real property. You would complete new titles for any vehicles that need to be transferred. You would cut the checks or make the wire transfers for any liquid assets in the estate. And eventually, once you have transferred everything to who it's supposed to go to, then you would ask the court to close the estate, letting them know that you've done everything that the will's asked you to, that the probate code has asked you to. And then the judge would issue your closing order.
That's a good summary. I would add just a couple, again, practical tips. When you get the death certificates, as Jessica said, usually from the funeral home, if for some reason they don't give it to you, get it from DHEC. But I would recommend getting a minimum of 10 copies because you will need them for a variety of reasons, life insurance reasons, just a variety of things. And they're minimal cost. The other thing I would get multiple copies of from the court is the order of appointment of personal representative, because again, as Jessica mentioned, you'll need to take that with you to the bank, to the safety deposit box, to any financial investment firms. You might end up needing more later. And it's not that they're hard to get. It's just more of a hassle, time consuming to go back and get more. So just practical tip to get more of those. If for some reason the decedent owns property in a place other than, if they die in Greenville County, they own a property elsewhere, either another county in South Carolina or another state, the probate court will guide you on how to handle that. You'll have to do an ancillary estate in that county, wherever that is. But it's not onerous. And again, the staff in Greenville County would be glad to help you get started on that. Or your attorney, if you have attorneys helping you.
Yes. Yes.
Well, I think, first I want to say we're so lucky, and especially in Greenville County, to have a fantastic probate and estate bar, as exemplified by Jessica here across the table from me today. And I would really encourage you to at least call an attorney, find out what a simple will, if that's all you think you need, just find out what a simple will actually costs. Because I think you've heard us say over and over in this conversation how important it is to do the planning on the front end rather than have your loved one have the consequences on the back end of not planning. If you feel like you're unable to afford the attorney, don't forget the other great resources we've mentioned. South Carolina Legal Aid is fabulous. They're very helpful, and they've done this many, many times, as well as the local bar, Greenville Bar, State Bar, and the Greenville County Probate Court, all resources that are full of people wanting to help you through this very difficult time. So again, thank you, Jessica. You brought a lot of great information and made it very clear for everyone. And I know people who have you as their attorney are lucky, and I appreciate your time today.
Yeah, thank you, former Judge Smock. It was nice getting to meet you in person, and I know that your willingness to share your experience on the bench is just incredibly helpful for anyone listening, anyone who's not an attorney, attorneys, other judges, and we're just excited to have you here.
Thank you so much.
Hi, Simple Civics Greenville County listeners, Nathaniel here. If you've made it this far, then we think you'll really love our newsletter. Sign up for bonus content, updates, and more right in your inbox. Look for the link in the description that says newsletter to sign up, or visit us at simpleCivicsGreenvilleCounty.org. Find the link in the menu that says newsletter and sign up there. We'll see you again next week.